We're live.
We're live. G'day, Karen. How are you?
I'm feeling great. It's the first day of the Lunar New Year.
And I have a prop.
You have a prop. There better be money in there.
You know there is, because I took it out before and they told me I was mean-spirited. So there you go. Happy Lunar New Year. From a dog to a dog.
And thank you. Double two hands, because that's respectful. Thank you so much. Wishing you good health, great prosperity, and that you get everything that you want.
Good. I want to get rid of this hangover.
Well, normally we're not normally trained to say those kind of things.
Are we?
No, not us anyway. So,
right.
Yeah.
Yeah, I am. Canda's everything in workplace.
Just a bit of context, dogs. We're talking about our Chinese zodiac, thing.
Yeah.
Because without context, that sounds pretty bad.
So can I just say, we're not only doing that. I've got a bit of purple here today.
Yes.
I've got purple shoes as well, because apparently dogs wear purple shoes.
Well, hang on. Your year of the dog. Your year of the dog. I'm year of the dog. Today is this year's year of the ox.
That's right.
I don't know. I've got to read the outlook for us. Look, I'm not terribly auspicious.
I think after Christmas and the amount of eat, I'm much closer to ox than dog.
No comment. Anyway, let's see. We should probably have a look in terms of how we're going. I know that everyone's starting to sign back in again. So we've got a great session to share with you today. Lots of content, very topical, which is the reason why we're spreading it across 2 weeks though.
Yeah, I think that's right. And start of the year, lots of things we're waiting on in our firm. We're waiting on decisions from the full court. There's lots of things about to happen. There's lots of stuff before the full court, before the High Court at the moment. So 2021 is an exciting year, not just if you're an ox.
Yeah, okay. All right.
So enough of that?
Yeah, enough of that.
What do you reckon? We kick off?
Yeah.
We're very, very close. So let's bring up just what we're going to talk about today, which is sort of next slide on our pack. So we are going to talk about vaccinations this week and whether you can mandate them, and that's going to be the major part of what we're going to talk about. We are going to talk about the IR Omnibus Bill and what that's about, and also a really interesting case of Carlton United Breweries and Johnson. But I think the most important thing, remember, this is not legal advice. This is just us having a chat and talking to you about what the issues are. But I think what we're going to talk about today for a lot of you is sort of really goes to the heart of what your business is about in the middle of COVID. We're not going to concentrate on COVID every week like we did last year.
Yep. Partly
because I think you've got COVID fatigue, partly because we've now got most of those strategies in place, so it's not such an issue. But let's talk very briefly about the Omnibus Bill that's come through. As you know, the Liberal government presently having a second reading stage, the IR Omnibus Bill. I think after working in employment law for as long as I have, one of the disappointing things is the polar nature of political debate around industrial relations completely forgets there's employers and employees. And therefore we have this three-tiered system in Australia, which no one else has, which is legislation, awards, and enterprise agreements. Don't worry about the contracts and all the other parts that sit around it. You end up with about 5 different sets of legal obligations, and we know our employers don't understand it, and we absolutely know employees don't. And that means you have this sort of internecine warfare that happens around, well, what are my rights all the time? So it came to me, I guess, as a bit of a surprise, given the level of complaint that is out there about how complex the IR landscape is, that this Omnibus Bill has done nothing really to simplify it all. In fact, it talks about award simplification, but that's really over a 2-year period. So I dived out of that screen. That's over a 2-year period flexibility around COVID. Well, that's okay, but it's not great, and it actually complicates the law as it already is. And there's a little bit about allowing part-timers who are 16 hours and above to continue at the same rate of hours rather than overtime. So there's some stuff which is a bit of tidying up. But overall, those great big lumps of documents that we look at every day as awards are not simplified at all.
Yeah, it's a lost opportunity, and look, IR has always been really complex. And like you said, those 3 tiers, here is the opportune time for us to simplify things for everyone who's actually involved and allow businesses to actual organizations to the true flexibility they need to actually be productive and to grow and to explore. and give employees certainty, because there's no certainty in terms of, well, what are my conditions?
I know. And look, so the second thing they were looking at is how to fix up enterprise agreements. So I looked at the HACS enterprise agreement, which is 180 pages the other day. We're not getting any inroads on simplification, are we there? It looks like there is a deliberate desire. I think all parties will support the approval process occurring within 21 days, because we're blowing out at the moment, Karen, sometimes 12 months to get an approval.
Yeah, that boot test really is really what's blocking it, isn't it? It's really making it hard.
It's making it hard, and the mechanism the Fair Work Commission do, which is have a bunch of young kids sitting through the bench book trying to show something's a bit wrong and then saying no. And this should have talked about going back to the no disadvantage test, which was a very simple, but again, that's another missed opportunity, and they're not going to do it. So they are going to introduce a sort of 2-year thing where you can go beneath the boot test because of COVID. Again, not really getting the point of what businesses need. Businesses actually need some really simple flexibility about when people work, based on when supply chain fails as a result of COVID or closure. Again, not in it. And again, you just wonder what's going on in people's brains when they can, are they chatting to employers and saying to employers, well, look, we've got a whole book full of orders, but we can't get supply through Europe. And therefore, some days we've got no work at all. And it's that type of thing that should be contemplated, because that's what people have every day.
It makes it easier for employees to have that conversation, right?
Yep. G'day, Brad. Good to see you, mate. We had a bit of a look around casuals. So there is a provision that they're suggesting if I say to Karen, you're a casual, and you sign the contract, you're a casual. I don't think that's the answer to the casualisation problem. And I think that process is going to be really frustrated. But one of the difficulties is Labor are not going to support a lot of this stuff. And so what we'll end up with as an IR bill is getting One Nation to actually agree to something. And, you know, that's not going to be a very refined adjustment. When you've got the person who has the least knowledge about IR and employers, and the least care about it as being the final hand that settles something, we know this is going to be pretty fraught. There's compliance provisions have been upped a little bit. There's some wage theft stuff, but not the quality work that was done with the Victorian government, but it's designed to exclude the Labor states who've done it. What we're seeing at the moment is all the states are trying to address the gaps in IR. So we now have another layer. So we've got Victoria at the moment with portable long service leave for security guards, cleaners and people, trying to address the inequities. And I guess this comes back to an issue we have to deal with, which is, what do Australians think is fair?
Yep.
And then saying, okay, this is what Australians think fair. Let's have legislation that's very, very simple, that respects that fairness. Let's not try and adjust fairness from person to person to try and make something happen, so that when you've got a cleaner and they come and work for you and they're on a contract, suddenly you find you're hit with a bill for 7.5 weeks long service leave because you were the last employee to cop them.
Yeah.
You know, that sort of stuff's crazy. And Victoria's tried to do that by making you pay into a portable system to manage it.
Again, symptomatic of a bigger issue.
Yeah, symptomatic of this, that nobody actually thinks about what's fair. What do Australians think is fair when you're employing someone? And then let's just build a system around it. Let's just wipe awards away completely.
What is fair if you don't understand it?
Yeah. Anyway, look,
I know we're going on a bit.
We are going on a bit, and that does reflect that I had a bottle of red wine last night, so I'll move forward. And the last part is there's opportunities for new greenfields for major projects to go for a longer period than the 4 years and 8 years. And we'll see what comes with that.
Yep.
So what we're going to do for you next week is we're going to have a document that will come out to you before the webinar, which will set out every element of what is in that omnibus legislation, how it is different than what was before, and the likelihood of it being adopted, so that you'll have a guide that you can read the news by about the omnibus bill going through and say, okay, it looks like we're going to get this, so we can start doing our planning. So you get the planning one. You've already got the vaccination thing we sent out to you, so you can see what we're talking about when we come to vaccinations day, and that's what we'll try and do with these major topics, is break it down into a bite-sized lump for you so you can follow the discussion that happens. Next thing is CUB and Johnson. Really interesting full bench case. So we've had lots of cases around what happens when Andrew Douglas, who is a labour hire provider, provides an employee to Karen, who is the host, and Karen doesn't like that person and says, take him back. And the issue is, in doing that, can I terminate the employee if I don't have any other work for them? So the law sits like this. If they're an employee who is placed with Karen, Karen has all the safety responsibilities, I have all the safety responsibilities. In Victoria, I have workers' compensation responsibilities, Karen has returned to workers' comp for my employee. You see how complex this is getting?
Yep.
There are some discrimination provisions, particularly around sexual harassment, that Karen has in respect of that employee. I have all of the discrimination provisions that relate to it. So the world's quite complex, isn't it? Once again. So what happened in CEB and Johnson was a mechanical fitter went to work on a palletizer and did something which, for want of better expression, breached a golden rule in safety. That's not what it was called, but what happened. Mm-hmm. They were already dissatisfied with his performance, particularly around safety, and they said, we will not have him back. Now, the really important thing about this is that CUB had vetted the labour hire contract and made it very clear in the labour hire contract that we have a right at any stage to refuse the use of one of your employees from the labour hire. Karen, I'll come back to the contract part of it in a minute. Mm. What happened then is that you've got the labour hire person saying, well, what do I do with this employee? And they terminated them. And at first instance, they were told to reinstate and to reinstate into CUB. CUB weren't part of the original thing. And CUB brought the appeal and said, well, A, you can't make orders to me, so stop it. And B, we're definitely not having this person back. And the full bench looked at it all and said, and it's a proper reason for termination in any event. So the case is really quite simple because Chelgrave, who was the labour hire, could prove that what the person did was serious misconduct and was fine. But what happens more often in labour hire usage is labour hire provides your greatest risk in an organisation, not your employees. And so you're constantly dissatisfied with parts of what they're doing. They don't buy into the mission of what you're trying to do. So well-drafted labour hire contracts that have been amended by hosts always say, I can reject. And a year or so ago in a case called Pettifer, what the full bench held was, if it's lawful to reject them, so we assume that's correct because you've got the contract to do it, if it's lawful to do it, and then the labour hire organisation cannot find, after a suitable search, employment for the person, it is a valid reason to terminate because they have no capacity to employ them. Mm-hmm. So that's a really important case, and I know there's a number of you in labour hire land out there who we work with.
So just on that, Andrew, so the key takeaway here is that when working with labour hire agencies and when engaging labour hire agencies, it is absolutely imperative that you sit down, that you under those terms and conditions, that contract that's issued in terms of setting your agreement, understand what that means, understand what the implications of that mean. That needs to really be the labour hire and whoever is representing the organisation really having a conversation around that. And in terms of, okay, so what if this happens? How do we manage that? What's your process? What's our process? How do we make sure that we honour this in the right way? That would have prevented that.
Completely. And looking to an extent in CBU and Johnson, that's exactly what occurred and which made CUB completely safe from it. So I'm just putting out there a really interesting case and reminds us that labour hire also have power, but they must look for suitable alternative employment. And if they don't have it, then they can terminate. So let's head on to our next slide, which is around vaccination.
Topical.
It is topical.
Dominating all the dinner conversations with anyone who's working in HR, anyone who's owning or running a business right now is asking this question.
So very simply, let's talk about the safety law because that completely controls the outcome. Safety law says that an employer has an obligation to provide a safe place of work. They must do everything that is reasonably practical. So they have to identify the hazard. We know what the hazard is. Mm-hmm. So we know it's COVID. We know what the level of risk is. It's extraordinarily high. And we know that the basic controls that we utilise, which is social distancing, mask wearing things, are a group of things which, if you have them together, are good, but none on their own are successful.
Correct.
Okay, so you can social distance, but if people can sneeze on someone, it's all over. We know that mask wearing cuts between 30 to 60% of the level of exposure of transmission. It's not 100% unless you've got a face inside, a whole shield and mask to actually prevent it. Okay, so we know those things. So the issue for us is when you look at the science, and you'll see we're sending out to you again the full article soon, which has all the science in it as well. We'll just talk very briefly what the science is, but I know based on reason and practicability, if someone isn't vaccinated, I know these things. One, they can be infected. B, I know they can be infected by somebody who has been vaccinated, who will not get a serious illness, but can transmit it, and that's with all vaccines. So we've got a person who we have a responsibility to provide a safe place of work, which we can't provide a safe place of work. Ouch. That's hard, isn't it?
Well, what we're saying is everyone's a hazard with arms and legs and eyes.
That's right. And we also have an obligation to other people who we deal with under Section 23 and Victorian like provisions. So, and we know that lots of them won't be vaccinated. So if we use a meat processing work or health workers, which are the first two sets of vaccination, we know that they'll be bumping into people all the time who haven't been vaccinated. And therefore, people they care for or people they work with or people they go home to, we know that they're creating a risk, okay? If they create that risk for a person who works on site, it's a breach of safety legislation. Off-site, it's still a breach of common law. And remember, you know, we're chatting about this over a coffee as I was trying to sustain myself for this presentation. My third coffee.
You're doing all right.
I'm doing all right.
Yeah.
What we came up with is it's not going to be the regulator. They're not going to prosecute you for not vaccinating someone.
Yeah.
Okay. And by the way, I can't grab Karen and stab her with an injection. I'm not allowed to do that.
You could try. Good luck with that.
Well, I'll take my money back. Let's go off that. But I can require it and say, look, it's part of the inherent requirements of your job. And the more it is part of the inherent requirements, like in meatworks where the risks are so high, like healthcare, aged care, those types of things, the stronger the argument is to say, it's a lawful and reasonable direction to do it. Okay? So then don't forget, sitting at the back of that, the employee's obligation is to exercise reasonable care, that is a competent person doing their job, not to expose others to risks and themselves. And their others are not just employees. So they can't say no. I guess that's what I want to say. They can't say no unless they have some form of protected attribute. So it might be that a person has a phobia around needles or has a religious belief, part of the Dutch Reformed Church. There's a couple
I would be thinking someone has an underlying medical condition where their health would be adversely impacted.
Yeah.
But you have to share that information. We'd have to know about that.
But then the difficulty with that is, Karen, can they work?
Well, that's the thing. But can you do the job then?
Yeah, and what we found in case of Arnold and Good Start is no. And this was a childcare centre where they set out a policy, and that's the really important part of this, is to set out the lawful and reasonable direction. You know, what is the direction? Pregnant women, yes, thanks, Margaret. Good. What is the lawful and reasonable direction? Why? So Margaret, just going back, Q fever is a classic example with pregnant women. Cannot be vaccinated with Q fever, but are very directly exposed and at high risk from Q fever. So what happens, and it's always part of all meatworks, that you cannot have pregnant women coming working. You've got to look for suitable alternative employment for the women who are doing it, okay? So that's a good pickup, Margaret. But the issue for me here is it's got to be really clear. You've got to have the policy. They had that in Good Start childcare. A person refused to get a flu vaccination and a termination process because they couldn't safely employ the person in the job. And Fair Work Commission approved that. There's a case coming up very shortly, Glover and Ozcare, which is looking about someone being placed on paid leave for refusing a flu jab as well. Policy is sort of pretty critical. So the issue is, because control is a key part of what you're doing, can you control it? The answer is, if I can't place a person in a safe place, and I can't control it, then I probably can't employ them if I can't find some other method of protecting them. And we're going to investigate this in the problem we've got a little bit later, so I won't give away all the dice.
Yeah, sure. The
other issue is the people who are anti-vaxxers who are campaigning, and they're actually campaigning internally in organisations saying we shouldn't be vaccinated. And, you know, we saw the crazy case of Israel Folau where the argument was raised, which is complete nonsense, that there's a freedom of speech that exists where you can hurt somebody. Now, let's be really clear, that would have gone all the way to the High Court, and the High Court would have chucked it out and said, well, no, if what you do breaches a policy which is designed around inclusion and protecting people, religious freedom of speech is not going to survive it. And that's why the religious right has been trying to enshrine it into the anti-discrimination provisions to make it a positive right that supersedes all other rights. In Victoria, we have a Charter of Human Rights, which allows people the freedom of speech, and there's an implied duty that exists under the Constitution, but not where you contractually or through policy have a public health basis to protect someone's life. Then someone doing that is committing serious misconduct. And let's talk about how we define. So Section 12 of the Fair Work Act says serious misconduct. It's defined in Regulation 107. Committing an act that creates a serious and imminent risk of harm to somebody is serious misconduct. That creates a serious risk of imminent damage to the reputation of a business is serious misconduct. That fails to comply with a lawful and reasonable direction is serious misconduct. So let's have a look at our slides, Soph, if we can, with just walking through what are the arguments that exist. We've got a slide which has a diagram on it, and there it is. So if we go that and we say, look, can I vaccinate somebody? I'm pointing at a screen, you can't see that. Safety law and employment law says I can. What happens if they refuse? If they're a person who talks about anti-vax and refuses, well, you can terminate, or you can produce a sufficient control if that's possible. If they've got a medical or religious, well, does it prevent them from undertaking the inherent requirements of the job? Are there reasonable adjustments that are made? If not, you end up in the termination process. So I thought this was just a simple way of saying, go down this pathway, work out whether the control you've got for the person who is involved protects you both under safety legislation and at common law. Okay? Because remember, it doesn't have to be a workplace for common law. If I go out and I infect Karen and she doesn't work for us, but work could have prevented that through a vaccination process.
Look, for lack of a better term, the exposure is huge, right?
It is huge.
Yeah. So, and it's keeping it, just to simplify, it is about keeping people safe, keeping your employees safe, keeping the broader community safe, and in terms of the people which your employee interact with.
Yeah, and I think from what Karen and I do, we've been talking to a number of businesses who are now exposed to it, Karen, through the consulting business, me and Law. I want people to stick with just the sensible narrative, which is, look, we've spent the last 12 months protecting your life, your family's life, and our community's life. We're going to continue to do that, and we now have an opportunity, a control we didn't have before. So safety language is beautiful, isn't it? Because that's what it says. It says, we now have a control, and we know about this control can stop you getting sick, badly sick. We know that it may not prevent transmission, and the science is unclear. So we must have a control over and above the vaccination process that prevents that third thing. Yeah, I know. Look, it does. Margaret's just said she works in a sector where they have lots and lots of people who are anti-vax, and this is going to be a hard sell. So that's why I don't want people to be going around with a steel glove in their hands, punching people. It's saying, look, we're invested in your safety. And it's making clear as a narrative within the organisation, all the people, we're here to protect you, the people you work with, and your community. And we've done it for 12 months, but you actually got to come on board. And we're going to educate you and support you. But if at the end of the day you say no, we're going to go along this pathway and say, how can we have a control that's not like that? Well, if we have a superior control which prevents it, and it's a high risk, what does the hierarchy of control say? If you can eradicate it, and it's high risk, you must eradicate. Okay. And as I've said, the science is really out there as to whether there is any control which is a PPE based and administrative control. Actually, there isn't one of those that really, really works. And the meat industry is a classic example of, despite brilliant work in the meat industry around those controls, the problems that have
those
arisen.
Controls at those levels require they're combined controls to be maximize the effectiveness, and at that level you're really required supervision. That's
right. And if you've got an elderly relative who's in the trust of an aged care facility, and you say, oh well, look, we're going to just rely on PPE, well, that means that person's going to walk around in full PPE for their entire time until COVID's gone. It may never go.
I think they've got the PPE on correctly too, but that's a different matter.
Okay, well, let's go to the problem now. Okay. Now I'm going to have to get Karen to move something which you can't see on your screen.
That's okay.
Case study: digital difference. We'll call it DD. Develops software solutions for warehouses. Frank is a coder. Jenny is a salesperson for Western Melbourne, and Donald is a PA. Frank says he won't get vaccinated because he has no client interaction or staff interaction and can work from home. He's done so successfully for the last 8 months. Donald says he doesn't believe in vaccines and refused the company rollout. He is an avid supporter of Pete Evans. He says he thinks it is unlawful and keeps encouraging others to not be vaccinated, quoting Pete Evans. Jenny suffers from a condition called trypanophobia, a fear of needles. In the past, we've allowed her to not have mandatory flu vaccinations. Be very clear, if Jenny is approached with a needle, it will send her into panic and she'll not survive it. Okay, she'll completely break down.
Mm-hmm.
Jenny is both a client and staff-facing person. All right, so let's go for the poll, and I'll get.
All right. Okay. We ready for it?
Let's go. Launch it.
Launch.
Okay, we're starting to get numbers, which is good.
People are thinking. It's a lot to take in.
It's a lot to take in. It's actually quite interesting. I wrote this before I went out having a drink last night. These are quite good questions.
Yeah, they're all right.
I'm surprised by them, actually. All right, let's wait for another 14 seconds.
Yep. All right.
Okay, let's go.
Let's go. We'll end it now. Thanks everyone for participating. All right, let's share these results. Yep.
Yeah, share the results. So look, the Frank question's really interesting. Frank's the coder. He works from home. He probably drinks Diet Coke. He doesn't mix.
Stop it with that. Anyway, go on.
He doesn't mix a lot, okay?
It's a better way of putting it.
But the answer is, we've lost something there. I don't know what happened. We were going well and something has disappeared.
Oh, we're still here.
We're still here?
The slides are not there.
Okay, the slide's not there. Good. So the answer for Frank is he is at a lower level of risk. I think all our officers now understand, and coding is another example of people who are involved in undertaking challenging processes, and the evidence is very clear that neuropsychological engagement doesn't happen over Zoom to the extent that it happens in person. So you are probably going to need to bring him in. So there is a real problem about bringing him in. And of course, if he doesn't come in and he's infected, and he does decide to come in one day and infects other people or infects clients or does anything like that, there's a risk. But I think in the short term, the current controls we have around Frank can be exercised and you can start doing the work on it. But the moment you move out of working from home, Frank comes right into the target of saying, no, you've got to be vaccinated. And I think Frank will probably agree to that. Donald's a more difficult character, really, isn't he? Because can we stop him from undermining your vaccination rollout? Absolutely, by giving him that lawful and reasonable direction, explaining to him the public health issue that's behind it, being really clear to him and giving him a letter that advises him of that. And then if he breaches that, you've got all the provisions under Regulation 107 of serious misconduct, okay? Don't be too scared of people trying to damage the reputation by using social media, because your social media policy should be absolutely clear that you can't say things which are contrary to the policy of the organisation. And that's the Israel Folau argument, isn't it? How do I control what might people do on the outside that attacks and damages the reputation or causes an imminent risk to people? So how you craft your policy, very, very, very important, okay? Must think about social media. Can I terminate Donald for failing to comply with the lawful and reasonable direction? I put out my warning shot at this stage, which is, yes, you can. The law says you can. The issue is, what is the process that you're going to do to get there? Because as Margaret said earlier, there's a whole lot of people out there who, for reasons of conspiracy theory or some pseudoscience they've read, don't want to be vaccinated. And we don't want to be people who are bullying people into vaccination, because we will actually get some reputational damage out of it. So if there is a way we can educate and grow people and create that simple narrative that gets them there, but at the end of the day, if Donald has, which he does, a PA, a staff-facing role where he is constantly at work and exposing himself to risk, he's breaching his Section 25 in Victoria and similar obligation elsewhere. He's failing to comply with the obligation, which he must comply with the direction under Section 22 in Victoria and similar provisions under primary duty. And he's getting awfully close to committing a crime under the safety legislation because he is reckless in relation to the chance of infecting or harming another person. And if he did, then he could go to jail. Now, if someone can go to jail, they can be terminated. Does that make sense? Okay, so the last question, I think, Karen, if you could just roll down
Yeah.
to the last question. Here's a hard one, and I guess I deliberately threw it in, but this is a very genuine medical condition that Jenny has. And so the issue comes for us is, well, can she do a job? And the answer is, well, she can do a job to the extent that we can wrap her in PPE when she goes out.
Mm.
She's a salesperson, turning up in PPE is going to make her engagement a bit complex. But there's a certain level that we can do, and we can say to clients, and if she has a good relationship with clients and we explain, we reach an agreed communication with her, I think there's controls, reasonable adjustments that we can make around her. But you'd want to investigate them thoroughly, because this is the most contentious. This is an adverse action risk. This is a discrimination risk. But most of all, this is reputational risk running at you. Here is a woman with a genuine medical condition you sacked because you're trying to protect people against a medical condition.
Yeah.
So good discussion with clients. Say, look, Jenny's going to come and see you. Jenny is going to wear a face mask. She's going to be quite serious about social distancing. Can you just remember that? And the reason for that is Jenny is unable to be vaccinated, I have to say, because she's phobic of needles. You okay with that? I think in Australia, nearly everyone is going to say yes.
Yeah, although she's going to have to do them virtually, even though it's not going to be quite the same.
Yeah.
But those are things that,
Yeah, so look, if you can't do it, and that's the bottom line, and by the way, you as a group have been fantastic because you've picked up that variety all the way through, then the answer is you could. But my strong thing is this is a communication game. This is about pushing the values of an organisation and having appropriate narratives that engage people rather than going straight to pulling the trigger.
Mm.
Now that's it for this week as far as what we're doing. Just to let you know, next week we're going to do the second part of vaccination. So any questions you've got, please send to us, okay? Because that will form the basis of a deeper dive into the science of it, so that when you're having these discussions, we'll talk more about controls next week. We'll talk more about what the science says and how you can do it, and we'll look at a more complex problem. We'll also give you the update on the Omnibus Bill, and we'll give you the latest cases. And it's just lovely to have you back, and it's fun being here. So thanks, Karen. And again, Happy New Year.
And to you too. Can you say that? Oh, he tries. At least I've got to give you that, right? Anyway, have a great weekend. Thanks everyone for joining us.
See you later, guys. Thanks very much.
Bye now.
Bye-bye.